You need that chocolate. Yeah, I know they are. It's not cut. I think I can't call that. What's that? I'm gonna wear it. All rise, the separate session of the Hamilton County County meeting for the general session. The honorable Wendy Crawford presiding. Please be seated, remain quiet, turn off and put away cell phones. Thank you.
All right, good morning. Madam Prosecutor, begin first.
Johnny Pickett.
All right, is he here?
He is, Judge, he's in the hall. I can waive his appearance, we'll bring him in as the court.
Can you bring him in?
Absolutely, Judge, come on. I'm sorry. Sorry, Judge, we have to have him wear the mask.
Thank you. All right, this is a matter of State of Ohio versus, is it Jamie or Johnny? Johnny Pickett, case number B 2200832. Mr. Pickett is present in the courtroom with his attorney, Mr. Paul Hoffman, and Ms. Jackie Stokoliak is present on behalf of the state of Ohio. This matter is on a pre-conviction habeas return. It's set for a plea. I don't know why the Sign Commission did that, but it's not a plea. Mr. Pickett habeas on his trial date, and we're here now. So, Mr. Hoffman, how do you want to proceed?
Judge, the procedural history you laid out is absolutely correct. Mr. Pickett, or Cavius, Your Honor said a $50,000 straight bond at that time. He was arrested on that warrant. Unfortunately, he was arrested in concert with some new charges. Those matters are still pending the grand jury's action, so we don't know what that's going to be. We ask that this case be continued to allow those new cases to catch up. Those will obviously roll to Your Honor, and once they are consolidated, we will address them. Mr. Pickett apologizes to the court for his failure to appear. He was scared and made some stupid decisions. I think this new case has kind of caused him to realize that sticking your head in the sand doesn't help. It only makes things worse. He's been compliant with all of his bonds. He's appeared here this morning as required by the court. We ask to come see you in approximately 30 days when we know the outcome of these new matters.
State.
I do not have an objection to continuing these to see what happens with the new cases and allowing everything to follow. I would ask, and I know that you're articulating things in writing, at EMD, he had it as a condition, Mr. Pickett's bond. I do understand that he is here today, but the only reason he is here is because he picked up those new charges. Those new charges actually involve a pursuit for Mr. Pickett, crashed his vehicle, which is probably one of the only reasons why he was detained. And while the case was not issued until September of last year, there are notes in the file indicating that as of August of last year, Mr. Pickett stopped attending court hearings. Mr. Lockman was not able to get in contact with him. So he's just been missing much longer than the previous records.
There's only a couple of responses if I could. Number one, obviously, everything I said is true, and he's standing here today, which was critical. Number two, the court and all of that would accept the bond back then. Number three, all those matters are still pending before the grand jury. I would simply clarify, there was no fleeing and leaving charge. This is not a high-speed chase. I don't want the court to have that understanding. I know there was an accident, but he wasn't charged with trying to evade the officers. Number four, I know what I'm up to. Once we see what comes out of the grand jury, questions on there may not be addressed in the revision process. So I would kind of let that play out. Mr. Pickett has satisfied his requirements to this court by appearing on the bond you set in this case. To the extent that new charges are going to be considered, that ought to be done in due course, post-action by the grand jury.
Well, I did not set the bond that he's currently on now after being arrested. Mr. Pickett had a trial date, a jury trial date, and he failed to appear. The court takes that very seriously. It was a trial, it wasn't a status conference, and he didn't show up. Then next time I see him, he had been arrested on new charges. The court, I guess it was a municipal court judge, set the bond, and I get to review it. So I think it's reasonable to make the request to add EMD, and I'm gonna grant it, so I'm gonna put him on EMD. And that's the least restrictive, because I was considering taking him to custody. But I'm gonna put you on EMD, and you are to make every appearance. You are to continue to communicate with your lawyer. If your lawyer comes in one time and tells me that I can't even get in contact with my client, that's a problem, you understand? But that's not really gonna be a problem because you're gonna be here every single time. So I'm gonna modify the bond to add a condition of EMD. We need to set a trial date. Now, I understand he has new charges, but this case is getting old. And, I like to keep everything together, but that case has nothing to do with this case. And this case is old, it had been set for trial, and he didn't show up. So I'm gonna set the trial date. Ms. Howard?
Judge, if I could, and I understand everything Your Honor just said, we had a plea worked out in this case.
I see.
I know that Your Honor wants to move the cases forward, I understand that. The trial date we ultimately had was what I would call, at best, not a real trial. We said it intentionally because I had not had contact with Mr. Pickett. Your Honor, I believe very correctly, made the decision that since his appearance had not been ordered at pre-trials on the court's entries, that a trial was not appropriate. We then set a trial date, I think, sort of to call the question. So, again,
And I get that, there had been we had reached an agreement, but what if Mr. Pickett changed his mind? He has the right to do that.
he does, Judge, but realistically, with these cases structured in the way they are, his appearance tells us everything we need to know. We have a deal worked out, at least in principle, on the old case. These new charges are gonna come in. At the very least, I'm asking for a brief period of time to figure out that a resolution can't be.
A global resolution.
Yes,
I
absolutely. And since
So-
we're already halfway home, it seems logical.
So if he is not indicted on new charges, we have it resolved.
I would say absolutely. The state is, I'm sure, has its feelings hurt about the passage of time. We will address that in due course.
Well, I was like, as Your Honor correctly pointed out, Mr. Pickett could have changed his mind. This has gone through several prosecutors, and the prosecutor's office could change their mind about the previously offered.
We understand that as well. And we'll understand all of these things better once the new charges hit. And assuming there's something, we'll come back to the table regarding a global resolution.
So
Grand jury report is on the third, February 3rd.
okay, that's next week. Okay, so then
Well,
let's
again,
do the,
Just to track that case, if that grand jury report's on the 3rd,
Yeah.
it'll be indicted on the 10th. That court will automatically be set for DSC, whatever your honors, 2 weeks later. So that would put us during the week of February 20th.
yeah,
Instead of dating this case during that week, the assignment commissioner will connect the
Right.
DSC. to
I'm
this.
thinking of March 1st. March 1st.
Good day, for me. Thank you, Judge.
All right, clear trial setting, March 1st. This is what I'm expecting to happen on March 1st. One, I'm expecting Mr. Pickett to be here with no violations for being here. And I'm expecting that council will know if he's indicted and will have started to have whatever discussions you all plan to have by March 1st. That's why I'm moving it out to March 1st. March 1st, I expect you all to come in here and say either this is gonna be resolved by plea or it's gonna be set for trial. Okay?
Very well.
All right, wait time?
So, Judge,
All right, thank you very much.
and he'll report to the MDB.
Yes, thank you very much.
Thank you.
All right. Who's next? Good morning. All right, Madam Prosecutor?
I believe Mr. Bobo is ready on a plea, but the client is locked up.
Is client's locked up?
Yes, Your Honor.
All right, what's your client's name?
Adrian Powers, Your Honor.
Adrian Powers. And all right, let's see, counsel. Good morning. All right. The reason we're all to wear masks, because I had abandoned the mask requirement and everyone mask is optional. However, in the middle of a jury trial, one of the attorneys had RSV, very contagious, and didn't tell anybody. exposed me, the client, the prosecutor, all the jurors, and I decided that I can't trust that people will be honest about their own medical condition. And in order to keep everybody safe, I have to require masks. I hate these masks. I know you hate these masks. But I need to get back to a point of comfort that people will self-report if you are sick, you're feeling sick, or you have a cough. So I haven't quite gotten there, but I'm going to say today that if you know that you are not sick with the flu, a cold, RSV, or COVID, and you know that, you feel comfortable, you may take your mask off. But as soon as I hear coughing, I'm gonna ask you to put your mask on, okay? So that's just my effort to try to keep everybody safe. I'm not trying to be oppressive. It's just that happened 2 weeks ago. So if you feel comfortable and you know that you have, your medical condition is fine, and you know, you can take your mask off. But you may decide you want to keep it on just because, that's fine too. So I'm gonna let it be optional today, okay? So. Mr. Bobo, your client is going to go down.
Thank you very much.
Yes. Okay. So, split the registration. So, actually, so they lower them. And so basically, yeah. So she. So he's. It was a stable 5%. It's essentially the equivalent of 5%. Yes, it was really
anyone ready to find us in the Justice Center?
We can call Kira Israel, Your Honor.
Okay.
Hi.
This is the matter of State of Ohio versus Kira Israel, case number B 22038895. Ms. Israel is present with her attorney, Mr. William Oswald, Ms. Jackie Stachowiak of the State of Ohio. This matter is set for status report, and I know that the officer was supposed to be here today, so that this is discovery exchange or something like that. In any event, we do have a trial date, March 20th, and a final pretrial conference on March 9th. Mr. Oswald, what's the status?
Your Honor, I believe the discovery is still outstanding. Prosecutor explained there's additional video and other information. She now knows how to obtain it, but we don't have it today.
State?
That is correct, Your Honor. I notified the two primary CPD officers for court today. Upon receiving that notification, one of the officers emailed me to indicate that they were both unavailable for court today and also to kind of give me a little bit more information. So there's a third person who is an agent of, I believe, the Ohio Department of Public Safety, who I've been emailing with, who unfortunately is also unavailable today. But I do have a better understanding of the facts of the case, which I relayed to Mr. Oswald, as well as the other outstanding discoveries, because people are out of town today. I was unable to get for today's date. Because I do know what is going on and I have contact information for everyone. I think that I will have everything prior to our March 9th final pre-trial date. And I would just suggest picking a date sometime in February to make sure that I have everything.
Well, since they are unavailable, how about the court issues subpoena for all three? And then they can be here when I say they're gonna be here. Because this case has been pending for 154 days. And the defense doesn't even have discovery because people can't be here. That's ridiculous. That's ridiculous. So, I don't know if they're unavailable because of work, training.
I know, the agent with the Ohio Department of Public Services, is out of town for screening. The other two officers are just out of town. They did not specify if that is work or personal.
Sounds like they went to the game. So, I'm gonna set this for, do you know that the officer who's in training, do you know, when he'll be back? Have any idea?
I believe he said he's out of town this week.
All right. Well, I'm gonna set this for, I'm gonna leave it on March 9th. However, I'm gonna order the state to give the discovery to the defense by, what's next Monday's date?
6.
February 6th. All right, state is ordered to provide discovery by February 6th. Now, I'm not putting another date on the calendar, but if you want to provide the names, I can order, do a subpoena so the officers can be here. If you think that's necessary.
I'm in Butler County in the morning, you want to do the 7th. I can be available the 7th, but I'm in Butler County in the morning. If you're gonna issue subpoenas.
Well, all right. I will make the date the 7th. The state has to provide the discovery by the 7th. And Mr. Koliak, do you prepare the subpoena or do support?
I can do a notify, which is not
That's not enough.
correct.
I'm just. So give the names to Ms. Howard,
Okay.
courtroom will subpoena. All right, so I will put that Ms. Israel was present. Counsel, if you want to waive your client's presence for next week, that's fine. I'm not putting it on the docket. All right, I'm just doing a subpoena. They're gonna have to show up. So if you show up, they show up, that'd be great. Y'all can talk and do whatever you need to do. I'm not gonna be involved in that. I'm just gonna get them here. Okay? And so, the next time your client has to come for court will be the March 9th, unless you ask for another date. Okay?
Okay,
All right.
thank you.
All right, thank you very much. Ms. Howard, if you wouldn't mind, this, to collect and give the names of the officers, we're going to have this subpoena for February 7th at 9 a.m. This is a matter of State of Ohio versus Adrian Powers, case number B 22-04870. Mr. Powers is present in the courtroom with his attorney, Mr. Kevin Bobo, and Ms. Jackie Sokoliak for the State of Ohio. This matter is on today for plea, and I have the handed plea documents. Counsel, is this how your client wishes to proceed?
It is, Your Honor.
All right, Mr. Powers, is that accurate?
Yes.
Are you the Adrian Powers named in this indictment?
Yes.
How old are you? 25. And how far did you go in school, Mr. Powers? So you're able to read and write the English language well?
Yes.
Mr. Powers, I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize Mr. Bobo's signature here, but right here, is this your signature?
Yes.
All right, can you see it?
Yes.
This is an acknowledgement by you that you understand you have a constitutional right to have a trial. But when you sign this form, you're indicating to the court, I understand that, but I don't want to have a trial. I'm waiving my right. Is that your understanding of what you were doing when you signed this form? Did you sign this form after consulting with Mr. Bobo about your constitutional right to a trial? Do you have any questions about this form? Do you have any questions about your constitutional right to a trial? I also have in my hand a 3-page document entitled Entering, Withdrawing Plea of Not Guilty and Entering a Plea of Guilty. And up here at the top, it says Agreed Sentence Plea. On the 3rd page of this document, there are signatures. I recognize the prosecutor's signature here, that's Ms. Oswald's signature.
Yes, this was set originally last week when Ms. Oswald covered because we had a room switch and then there wasn't time to do the plea.
I
So we keep the consultant.
Yes, and I do recognize her signature there, but you're in agreement to this.
I am.
All right. And then I recognize Mr. Bobo's signature right here. And then up here, is this your signature? You can come closer if you need to.
Yes, ma'am.
All right, thank you. Madam Prosecutor, would you please put on the record the party's expectation regarding the plea?
Yes, Your Honor. Mr. Powers is before the court in a 12-count indictment. This time it is my understanding that he is going to be entering a plea of guilty as charged to count 3, trafficking in a fentanyl-related compound, a felony of the 5th degree, count 6, possession of cocaine, also a felony of the 5th degree, and count 9, trafficking in a fentanyl-related compound, a felony of the 3rd degree. In exchange, I would request dismissal of the remaining counts in the indictment, and all parties are recommending an agreed 12 months in the Ohio Department of Corrections as far as the sentence is concerned.
Is that accurate, Mr. Bobo?
It is, Your Honor.
All right, is that your understanding too, Mr. Powers?
Yes, ma'am.
Mr. Powers, are you under the influence of any medications, alcohol, or drugs today?
No, ma'am.
Do you now, or have you ever suffered with or even been diagnosed with any type of mental health difficulties?
No, ma'am.
Are you presently under any type of probation or community control supervision in this state or any other state?
Yes.
Can you tell me about that?
For-
Parole in
Yes.
Ohio?
Yes.
Okay. So you're on PRC?
Yes.
All right. Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
No, ma'am.
Has anyone promised you anything at all if you enter into this plea of guilty today?
No, ma'am.
Are you making this plea of your own free will?
Yes.
Now, the state has indicated that out of this 12-count indictment, that it's expected that you would be entering a plea of guilty to 3 of the counts, count 3, 6, and 9, and that after that, the state is going to ask the court to dismiss the remaining counts. Is that your understanding?
Yes, ma'am.
And that in addition to that, you, through your attorney, and the state have come to an agreement on the type of sentence to recommend to the court, and that recommendation is that you serve in the Ohio Department of Corrections 12 months with credit for any time served in the Justice Center. Is that your understanding?
Yes, ma'am.
All right, is that what you talked to Mr. Bogo about today?
Yes.
Okay. Did you have an opportunity to review this 3-page plea form with your lawyer before you signed it?
Yes, ma'am.
Do you understand what it says?
Yes.
Do you have any questions about it? Did Mr. Bogo answer all your questions about it?
Yes, ma'am.
Do you understand that while you and the state have made it a recommended agreement or an agreement to recommend that you serve 12 months in prison, that I don't have to accept it?
Yes, ma'am.
All right. Now, I'm not indicating that in any way that I won't, but I don't have to, and you need to know that. You understand?
Yes, ma'am.
Knowing that the court is not obligated to accept your sentencing recommendation, do you still want to plead guilty?
Yes, ma'am.
Now, Mr. Powers, you believe you had enough time to fully consult with Mr. Bobo about your entire case before this hearing today?
Yes, ma'am.
And has your lawyer answered all of your questions to your satisfaction?
Yes, ma'am.
Have you had an opportunity to review and or discuss the evidence that the state has against you with Mr. Bobo?
Yes, ma'am.
Madam Prosecutor, would you please put on the record whether or not the parties have, whether the state has provided all discovery, including any Brady material, it needs to your knowledge?
The state has, Your Honor.
All right. Mr. Bobo, you acknowledge what you're saying?
I do, Your Honor.
Mr. Powers, are you satisfied with your attorney, Mr. Bobo?
Yes, ma'am.
Now, do you understand these charges against you? Count 3 is trafficking in a fentanyl-related compound, felony of the 5th degree. Count 6 is possession of cocaine, a felony of the 5th degree. And count 9 is trafficking in a fentanyl-related compound, felony of the 3rd degree. Do you understand those charges?
Yes, ma'am.
Do you understand that if you plead guilty to these offenses, you are making a complete admission that you committed the allegations contained in those 3 counts of the indictment?
Yes, ma'am.
And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes, ma'am.
Now, 2 of the counts being felonies of the 5th degree, that's count 3, trafficking in a fentanyl-related compound, and count 6, possession of cocaine. Those 2 counts being felonies of the 5th degree, do you realize and understand that you are facing up to 12 months in prison on each of those counts and up to a maximum fine of $2,500 on each of those counts?
Yes, ma'am.
You understand that as to count 9, trafficking in a fentanyl-related compound, that's a felony of the 3rd degree, that you are facing up to 36 months in the Ohio Department of Corrections and up to a maximum fine of $10,000.
Yes, ma'am.
You understand that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years. Do you understand that?
Yes, ma'am.
All right. Mr. Bobo, you completed this form correctly, but would you mind in the last column where it says may, you put up to 2 years?
It's my apologies.
That's okay. All right, so I saw your lawyer, add up to 2 years, nay, on each of, the, post-release control time. You saw him do that? All right, and that's what I just told you, I just wanted to reflect properly in your paperwork. And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence, do you understand?
Yes, ma'am.
Are you on post, just said you're on post-release control, aren't you?
Yes,
All right. Do you understand that if you are convicted of a new felony offense while on post-release control, that in addition to being punished for the new felony offense, which this is here, the sentencing court can add an additional consecutive 1-year prison term, or whatever time remains in your post-release control time, or whichever is greater. Do you understand?
yes, ma'am.
Also, because these are felonies of the 5th and 3rd degree, community control is a possibility. Do you understand that I could place you on community control instead of sending you to prison? Do you understand?
Yes, ma'am.
Also, I could impose court costs, and if you fail to pay those court costs, I could order you to do community service in the future. Do you understand that?
Yes, ma'am.
You have any questions?
No, ma'am.
When you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons?
Yes, ma'am.
Do you understand that you have a constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer?
Yes, ma'am.
Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify for you?
Yes, ma'am.
Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt?
Yes, ma'am.
And finally, do you understand that at trial, you cannot be forced to testify against yourself?
Yes, ma'am.
Do you understand each of these rights as I explained them?
Yes, ma'am.
Do you have any questions whatsoever about your constitutional rights?
No, ma'am.
Do you have any questions whatsoever about anything we discussed today?
No, ma'am.
Do you understand that if you plead guilty, you are waiving or giving up all of these important constitutional rights?
Yes, ma'am.
Knowing everything the court has discussed with you today, Mr. Powers, do you still wish to enter guilty pleas to counts 3, 6, and 9?
Yes, ma'am.
All right, counsel, is there anything further before I accept the pleas?
No, Your Honor, thank you.
All right, may I hear a statement of facts?
Yes, Your Honor. Count 3 occurred on or about September 22nd, 2022, Hamilton County, Ohio. Defendant Adrian Powers prepared for shipment, shipped, transported, delivered, prepared for distribution, or distributed a Schedule I controlled substance to a fluorofentanyl. When the defendant knew or had reasonable cause to believe the controlled substance was intended for sale or resale by the defendant or another in an amount less than 1 gram. Count 6 also occurred on September 22nd, 2022, Hamilton County, Ohio. Defendant Adrian Powers did knowingly obtain, possess, or use a Schedule II controlled substance to wit cocaine in an amount that was less than 5 grams. Count 9 also occurred on or about September 22nd, 2022, Hamilton County, Ohio. Defendant Adrian Powers prepared for shipment, shipped, transported, delivered, prepared for distribution, or distributed a Schedule I controlled substance to a fluorofentanyl when the defendant knew or had reasonable cause to believe that the controlled substance is intended for sale or resale by the defendant or another in an amount that equaled or exceeded 5 grams but was less than 10 grams.
All right, anything on the facts?
No, ma'am.
Mr. Powers, did you hear what the prosecutor said you did?
Yes, ma'am.
Is it true?
Yes, ma'am.
What is your plea to count 3, trafficking in a fentanyl-related compound, a felony of the 5th degree?
Guilty.
What is your plea to count 6, possession of cocaine, a felony of the 5th degree?
Guilty.
And finally, what is your plea to count 9, trafficking in a fentanyl-related compound, a felony of the 3rd degree?
Guilty.
Let the record reflect that Mr. Adrian Powers was present in court with his attorney, Mr. Kevin Bobo, and that Mr. Powers was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Powers understands the nature of the charges, the effect of the pleas, as well as the maximum penalties which can be imposed. Finding them to be voluntary, the court accepts the guilty pleas and finds Adrian Powers guilty As to count 3, trafficking in a fentanyl-related compound, a felony in the 5th degree in violation of revised code 2925.03 subsection A2. And guilty as to count 6, possession of cocaine, a felony in the 5th degree in violation of revised code 2925.11 subsection A. And guilty as to count 9, trafficking in a fentanyl-related compound, a felony in the 3rd degree in violation of revised code 2925.03 subsection A2. Counts 1, 2, 4, 5, 7, 8, 10, 11, and 12 are dismissed at the state's request. Counsel, is there any reason why sentence should not be entered today?
No, Your Honor.
All right, are you waiting for PSI?
We are.
All right, we'd like to sound that, Mr. Powers.
Your Honor, we would respectfully request the court consider imposing the recommended sentence. It is true that it was on the PRC at this time, but the PRC goes back a long, long time. He was doing well, he was almost all the way through it, and then an intervening incident which he was not committing any crimes or anything came up, and the warrant was issued, and then went downhill from there. I have spoken to somebody that is close with Mr. Powers. Mr. Powers has got no dependents, he just has to take care of himself. And he has an opportunity that would be good for him. Unfortunately, he's out of town. And my suspicion is, my strong suspicion, is that when he is released from whatever sentence this court issues, he is going to be released on PRC, I do believe, because he was PRC at the time. And he's going to have to finish that before he's able to take his opportunity out of town. He's accepting responsibility. I've known him for a little bit of time. He's always polite with me and does what I ask him to do.
All right.
He's thrown himself in the mercy before.
All right, thank you very much, Steve.
Just the state would also recommend going off the 12 years. I'm sorry, 12 months. I was distracted by the moment. 12 months. Sorry.
Yeah, but you're gonna give Mr. Bobo a hard time. Yeah, I know, you almost jumped out. I know. It's all right. All right, Mr. Powers, anything you want to say?
Actually, I just asked that you show mercy on my case, and I want to say that I apologize for my offenses against the state, and for my past offenses against the state, actually. So, I just ask that you show a little bit of leniency on me. I am a good person, and I am very intelligent, and know how to do a lot more things than I'm a good team for today.
All right, thank you very much. So what was your why were you in prison before?
I can speak up, you want me to speak up?
Yeah,
So he had, as I understand it,
in general, just as.
it was a burglary charge that the co-defendant that was given probation was related to him and knew when his family or whoever it was, cousins were gonna be out of town, and then he went to the residence with the co-defendant, who's a family member of the resident. And so when push came to shove, he got probation, and Mr. Powers had to a felony, the first-degree burglary charge, and that's where he was on PRC from.
I see. And that was the only time he was.
It was, yeah, there's nobody in the house, yes, they could have been present, but they knew that they were out of town. Pursuant to the code.
All right. So then you end up deciding you want to sell drugs?
Actually, it was kind of like a worse situation, kind of, because I already had the opportunity going, as you heard before. I was about to get off PRC. I've been doing well since I've been home, actually. And the PRC situation kind of is like a revolving door, so it's on the way, you know what I'm saying?
The warrant being issued,
Yeah.
the downward departure.
Oh, I see. All right. Well, let me tell you something, Mr. Powers. You said that you're a nice person. I don't have any reason to doubt that. But guess what? There's a whole lot of nice people that stand where you are. And you said you're an intelligent person. I don't have any reason to doubt that. there's a whole lot of intelligent people that stand where you are too. So that's not even the issue. The issue is choices. That's what the issue is. What you choose to do and what you choose not to do. That's what sets people apart from sitting there and sitting here. Choices. So, with your nice self, with your intelligent self, you need to make better choices. That's what life comes down to. And I understand that some choices are more difficult than others. But at the end of the day, that's how you have to look at it. You have to look at the choice and count the cost for your choice. That's what life is about. Counting the cost of our choices. So, I hope that you take this time to think about what better choices you need to make and how you're going to make them when you are under pressure, under life's pressure. Okay? All right. The court has considered overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using the minimum sanctions that the court determines accomplish these purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I've also considered the joint recommendation of the parties. I've also reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I've also considered the seriousness and recidivism factors set forth in revised code 2929.12. Accordingly, I hereby impose the jointly recommended sentence of 12 months to serve in the Ohio Department of Corrections on each count to run concurrently with one another for a total term of 12 months in the Ohio Department of Corrections, with jail time credit for 130 days plus any days of conveyance. Because you have been incarcerated, the costs and fines are remitted. I want to notify you that upon your release, you may be on post-release control for up to 2 years. Do you understand?
Yes, ma'am.
Anything else, counsel?
No, ma'am, thank you. I did have a affidavit of agency that I had Mr. Powers got. He does not have to ask us to pay him in for it.
All right, thank you very much. I will accept this and find that he is indigent and put that in my sentencing judgment entry.
Thank you.
You have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. Do you understand?
Yes, ma'am.
I wish you well.
Thank you.
All right. We need to bring down Mr. Magnus's client, and then let's see anyone else who doesn't have anyone.
Just my client is out.
Okay, Mr., let's plan to do yours, Mr.
Good morning, Judge. I must be too short to be seen.
But we saw your hand. All right. Okay, we're gonna, Mr. Harris, you have two, right, and Mr. Anderson?
I do, Your Honor. I need a first round.
Yeah.
Judge, we did notice that he was indicted on the original period. I don't know if my first Mr. Monday and off at the court. I just noticed it when I looked at the indictment and plea form. Everything else has been under Ricardo, but the indictment listed as written. I just thought that, so I didn't want to bring that to the court's attention.
Thank you. So his official name is Ricardo?
That's correct.
Okay, thank you very much. All right, this is the matter of State of Ohio versus Ricardo Henderson, case number B 22011001A. Mr. Henderson was present in the courtroom with his attorney, Mr. Rodney Harris, and Ms. Jackie Stachowiak of the State of Ohio. This matter is set today for plea, and I have been handed plea documents. Mr. Harris, is this how your client wishes to proceed?
That is correct, ma'am.
All right, Mr. Henderson, is that true?
Yes, ma'am.
All right. Are you Ricardo Henderson named in the indictment, even though it says Richard?
Yes, ma'am.
All right. And how old are you, Mr. Henderson?
66.
66?
Yes, ma'am.
All right. How far did you go to school?
I'm graduated.
So you're able to read and write the English language well? Mr. Henderson, I have in my hand a single-page document entitled Waiver of Trial by Jury. At the bottom, there are signatures. I recognize Mr. Harris's signature here. Is this your signature here, sir, where it says defendant?
Yes, ma'am.
All right, can you see it from there?
Yes, ma'am.
All right. This is an acknowledgement by you that you understand you have a constitutional right to have a trial. But when you sign this form, you're indicating to the court, I understand that, but I don't want a trial. I'm waiving or giving up my right to a trial. Is that your understanding of what you were doing when you signed this form?
Yes, ma'am.
Did you sign this form after consulting with Mr. Harris about your constitutional right to a trial?
Yes, ma'am.
Do you have any questions about this form?
No, ma'am.
Do you have any questions about your constitutional right to a trial? I also have in my hand a 3-page document entitled Entering, Withdrawing Plea of Not Guilty, and Entering a Plea of Guilty. On the 3rd page, there are signatures. I recognize Mr. Koliak's signature, the prosecutor here, Mr. Harris here, but up here, sir, where it says signature of defendant, is that your signature?
Yes, ma'am.
Madam Prosecutor, would you please put on the record the party's expectation regarding this plea?
Yes, Your Honor, Mr. Henderson is indicted in a 2-count indictment. At this time, I would ask that count 1 be dismissed as to Mr. Henderson. There is a co-defendant named in count 1. And I would ask that count 2 be amended and reduced to an aggravated assault, a felony of the 4th degree. It is my understanding Mr. Henderson is going to enter a guilty plea that amended and reduced charge.
All right, is that your understanding too, Mr. Harris?
It is, Your Honor.
Is that your understanding today, Mr. Henderson?
Yes, ma'am.
Mr. Henderson, are you under the influence of any medications, alcohol, or drugs today?
No, ma'am.
Do you now, or have you ever suffered with, or even been diagnosed with any type of mental health difficulties?
No.
Are you presently under any type of probation or community control supervision in this or any other state?
No, ma'am.
Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
No, ma'am.
Has anyone promised you anything at all other than the dismissal of count 1 in exchange for your plea on the reduced charge?
No, ma'am.
Are you making this plea of your own free will?
Yes, ma'am.
Now, the state has indicated that it's 2-count indictment, and the state is asking the court to dismiss count 1 in exchange for your guilty plea on count 2 that has been reduced and amended to aggravated assault, a felony of the 4th degree. So from felonious assault F2, felony of 2nd degree, down to a felony of the 4th degree, aggravated assault. Is that what you talked with Mr. Harris about before this hearing today?
Yes, ma'am.
Did you have an opportunity, sir, to read this 3-page plea agreement with your lawyer?
Yes, ma'am.
Did your lawyer answer all of your questions about it?
Yes, ma'am.
Do you have any questions as you stand here today about this plea agreement?
No, ma'am.
You understand what this plea says?
Yes, ma'am.
Mr. Henderson, do you believe that you've had enough time to fully consult with Mr. Harris about your entire case before this morning?
Yes, ma'am.
Has your lawyer answered all of your questions to your satisfaction?
Yes, ma'am.
Have you had an opportunity to review or discuss the evidence that the state has against you with Mr. Harris?
Yes, ma'am.
Madam Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material, if any, to your knowledge?
The state has, to my knowledge, Your Honor.
All right, Mr. Harris, do you acknowledge receipt of same?
I do, Your Honor.
Mr. Henderson, Are you satisfied with your lawyer, Mr. Harris?
Yes, ma'am.
Now, do you understand this charge that the state is asking to reduce and amend to aggravated assault, a felony of the fourth degree? Do you understand that charge against you?
Yes, ma'am.
Do you understand that if you plead guilty to that charge, you are making a complete admission that you committed the allegations set forth in that reduced and amended charge? Do you understand?
Yes, ma'am.
Do you understand that if you plead guilty, the court may enter a judgment of guilt against you and just proceed to sentence you immediately?
Yes, ma'am.
Now, this being a felony of the fourth degree, do you understand that you're facing a potential sentence of between up to 6 to 18 months?
Yes, ma'am.
Do you understand that you are facing up to a maximum fine of $5,000?
Yes, ma'am.
Do you understand that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years? And if you violate the conditions of post-release control, then you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand?
Yes, ma'am.
Are you on post-release control right now?
No, ma'am.
Do you understand that if you are on post-release control and you are convicted of a new felony offense while on post-release control, in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains of your post-release control time or whichever is greater. Do you understand?
Yes, ma'am.
Any questions so far?
No, ma'am.
Since this is a felony of the fourth degree, community control or probation is a possibility. Do you understand that I could place you on community control or probation for up to 5 years instead of sending you to prison?
Yes, ma'am.
Do you understand that if you are placed on a community control sentence, you will have to abide by all probationary conditions as established by this court?
Yes, ma'am.
And if I place you on community control or probation, and you violate the conditions of probation, then the court could order some more restrictive sanctions, which could include a whole host of things. But the most severe penalty could be the imposition of a prison term up to 18 months that we've already discussed. Do you understand?
Yes, ma'am.
Also, if I impose court costs and you fail to pay those court costs, I could order you to do community service instead of paying court costs. Do you understand?
Yes, ma'am.
Any questions so far, Mr. Henderson?
No, ma'am.
When you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial either to the court or to a jury of 12 persons?
Yes, ma'am.
Do you understand that you have a constitutional right to confront witnesses here in open court and have them cross-examined by your lawyer?
Yes, ma'am.
Do you understand that you have a constitutional right to have witnesses subpoenaed to come to court and testify for you? Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond reasonable doubt? And finally, do you understand that at trial, you cannot be forced to testify against yourself?
Yes, ma'am.
Do you understand any of these rights that I explained?
Yes, ma'am.
Do you have any questions whatsoever about your constitutional rights?
No, ma'am.
Do you have any questions whatsoever about anything we discussed this morning?
No, ma'am.
Do you understand that if you plead guilty, you are giving up or waiving all of these important constitutional rights?
Yes, ma'am.
Knowing everything the court has discussed with you today, do you still wish to enter a guilty plea to the reduced and amended charge of aggravated assault, a felony of the fourth degree?
Yes, ma'am.
Counsel, is there anything further before I accept the plea?
Nothing at this time, Your Honor.
All right, may I hear a statement of facts?
Yes, Your Honor. Count 2 occurred on or about June 11th, 2021, Hamilton County, Ohio, and as amended, Ricardo Henderson, while under the influence of sudden passion or in a sudden fit of rage, neither of which was brought on by serious provocation occasioned by the victim that was reasonably sufficient to incite Mr. Henderson into using deadly force, knowingly caused serious physical harm to another, Denzel Mosley. Do you waive further reading?
Wait for it, nothing on those facts.
All right, thank you very much. Mr. Henderson, did you hear what the prosecutor said you did?
Yes, ma'am.
Is it true?
Yes, ma'am.
What is your plea to the reduced and amended charge of aggravated assault, a felony of the fourth degree? What is your plea?
Guilty.
Let the record reflect that Mr. Ricardo Henderson was present in court with his attorney, Mr. Rodney Harris, and that Mr. Henderson was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Henderson understands the nature of the charge, the effect of the plea, as well as the maximum penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Mr. Ricardo Henderson guilty as to count 2, amended and reduced to aggravated assault, a felony of the 4th degree in violation of revised code 2903.12 subsection A. Count 1 is hereby dismissed at the state's request. Counsel, is there any reason why sentence should not be entered today?
Judge, we are asking the court for a community control center in this case, if the court provides us a little random we can provide, other than that, we are prepared.
All right, you ready, PSI?
We will.
All right, what would you like to say on behalf of Mr. Henderson?
Judge, Mr. Henderson is 66 years old, he's a lifetime resident of the area. He did serve our country honorably as a member of the Air Force and received an honorable discharge. Judge, he has worked at Gateway Plaza Hotel, he retired from there, he's now currently working at Down Community High School as a custodian. Judge, he is married and has children around him. We would ask the court consider the underlying facts in this incident. Judge, it was an isolated incident. What I've been able to see on the video, and also Mr. Henderson explained, he and his, whose name is his co-defendant in the first count, went to a pony keg in the College Hill area to redeem their lottery tickets. While there, they got to an argument / confrontation with the attendant. The attendant, and I've actually seen this on video, came from behind the counter and engaged his co-defendant. I think the evidence will show that the attendant was a very big man, probably 100 to 200 pounds more than his co-defendant. Mr. Henderson works as a custodian, had what we believe was a pocket knife with him, and he seen the attendant engaged in what he believed was choking out his co-defendant, and he did cut him. He cut him, he actually cut himself on the hand too, went to the hospital. He then surrendered himself to the police when we found out that these charges had been filed. Judge, he's been cooperative. It wasn't absolutely an isolated incident. It's my understanding that Mr. Henderson has not had any contact with this court for approximately 4 years. Again, he's taking responsibility for his conduct. He plans to have no contact with the alleged victim in this matter, and we submitted on that.
All right, thank you very much. State.
Defer the court, Your Honor.
All right, Mr. Henderson, is there anything you want to say before I pass sentence?
No, just made moral choices, like you said earlier. Moral choices.
The judge, he was held for one day for me.
What's the victim's name?
Denzel Mosley.
Denzel,
Yes, Your Honor.
M-O-S-L.
Mosley.
All right. All right, the court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender using minimum sanctions that the court determines accomplish the purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact not only on the victim, but also on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I have also considered the seriousness and recidivism factors set forth in revised code 2929.12, Accordingly, I hereby sentence you to a term of 6 months of community control, basic supervision, that's probation, basic supervision. You will pay court costs, there will be no fine. And let me ask, there's going to be a stay away from Mr. Denzel Mosley. Let me ask, does the state comply with Marcy's law?
This plea was previously offered. I honestly don't know, and there's not a note on it. And Mr. Harris was aware of it and actually reached out to me. I believe it was made with the agreement of the prosecuting witnesses at the time it was previously offered.
Okay, was there any restitution?
If there is, I'm not aware
Okay, no restitution. All right, anything further, counsel?
Nothing further, Judge.
State?
I would just ask for a stay away from the location of the Ameriscout where this occurred, as well as the victim.
All right,
And that is 951 West North Bend Road.
the nearest gas station?
Yes, Your Honor.
Ms. Howard, do you think with the address, can you say it again?
It's 951 West North Bend Road.
So they stay away from not only the Ameristock gas station at that location and Denzel Mosley, you understand? All right, you have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. Do you understand, sir? All right, you'll need to report right to probation right after court, and the paperwork will meet you there, so they'll be expecting you, okay? All right, thank you. Mr. Magnus, you have a,
Good morning, Your Honor.
you want to see your client, Mr. Magnus, real quick?
Your Honor, yes, I have a co-defendant with Mr. Ewing, but I'm just picking dates, whatever the court wishes to do.
Okay. Why don't you all come up while I let Mr. Magnus have a couple minutes with his client?
Want us to sidebar, Judge?
No,
Let me get my client. Thank you, Judge.
this is the matter, state of Ohio versus, Antoine Fant. Case number B2205882A. The B co-defendant is Mr. Jabari Walker. Mr. Fant is present in the courtroom with his attorney, Mr. Lewis, and Mr. Walker's attorney is also present, Mr. Tom Ewing. Mr. Ewing, do you want your client right now?
Mr. Walker would like to be present.
Okay, so I will,
address first. The court wants to address Mr. Lewis first, that's fine. Mr. My client has other matters that as well that need to be addressed.
Yes. All right, and Ms. Jackie Sequoia for the state of Ohio. First of all, he set a trial date on the co-defendants, okay? So, Ms. Howard, what date did you give Jabari Walker and Mr. Fant for the trial? And while we're looking for a trial date and the final pre-trial conference date, Mr. Lewis, there's a motion to modify the bond to remove EMD. What do you want to say on that?
Judge, may I please report that was a bond motion she previously granted for us. Our current clients at Campbellsville College, you granted the motion, Judge. EMD living room, he's in college, he broke in day.
All right, great.
Apologies for the confusion, she granted the motion.
Okay, thank you. I thought it was still pending. I remember allowing him to go back to school.
Yes, Your Honor.
All right.
And we do have discovery on behalf of Mr. Fant.
All right, you do. Do you have discovery on this matter, Mr. Ewing?
Not beyond just preliminary matters, Judge. Informal discovery.
You said yes?
Just informal discovery.
Okay. And you have the same thing, Mr. Lewis?
I believe what I have is, I thought it was formal, Judge, again, we've addressed motions, press issues, so we're satisfied from Mr. Fant's perspective, because there's more that's fine. We believe we have sufficient discovery.
All right, thank you. Yes.
If it was an assistant court, we can wait for the co-defendant judge. My client is out, he's going to turn college, whatever else the court will find, I'm going to co-defendant.
Okay, yeah, give me 5 minutes, we'll bring it down next.
Yes, Your Honor.
All right, Mr. Magnus, this is the matter of State of Ohio versus, is it Tamara? Tamara, nay, case number B 2206089B. Ms. May is present in the courtroom with her attorney, Mr. Magnus, and Ms. Jacobiak, present from the state of Ohio. This matter is set for motion for bond. We already have a clear trial setting date, March 1st, and we have a jury trial date set, April 24th. What would you like to say on behalf of Ms. May and Mr. Magnus?
Your Honor, I will assume you've read my motion. If not, I'll let it go back through.
Well, you should always assume I've read your stuff, okay?
Judge, I've made that mistake with other judges before, and I'm always gonna ask.
I appreciate it, but let me make it clear. You're in 380 in front of me. I read your motion.
I appreciate that, Your Honor. Your Honor, the purpose of bond is to assure her appearance and protect the community. It is not to punish her. She showed that she was willing to make her appearance when she got cited in room A. Frankly, as far as protecting the community goes, she lives in Indiana. She has no desire to come back here except for her court appearances and related matters. I will suggest to the court that frankly, to put her back in what was effectively an OR bond when she got cited, with an order to stay away from Walmart, no problem there, is appropriate. She did what was asked of her. She showed up in room A, and frankly, just about everyone's surprised, Judge Kissinger set a hefty bond that she and her family cannot make. And under the circumstances, we ask that the court said no OR bond with a stay away order.
All right, thank you very much. Steve?
I was going to say first concern is that Ms. May is not a resident of Hamilton County, which increases the likelihood that she may not appear. I was in conversation with Edward Louts, who is the law protection officer who's the prosecuting witness in this case. He is opposed to any reduction in Ms. May's bond. While it was just pepper spray, it was a significant enough amount that it was all over his face and was dripping down his head, his neck, and his back, and then ended up in other areas of his body other than his eyes. So for those reasons, he is opposed to any reduction in bond.
All right. So, Mr. Magnus, which Walmart were we talking about?
Evendale.
Evendale. And Ms. May is a resident of Indiana?
Yes, Your Honor.
I see. What part?
Indianapolis, I believe.
Oh, Indianapolis, so hour and a half away. Hour 45 minutes.
In that neighborhood, Your Honor.
Yeah. Perhaps that was the reason Judge Kissinger made the bond was the way it was.
Your Honor, I suspect it had more to do with the Evendale police showing up in room A, which I don't have to tell you how unusual that is, and asking that a bond be set.
I see. The bond right now is for $30,000 at 10%. And this is a F2 robbery. I think given all the circumstances under Rule 46 and I'm going to leave the bond as is. I think the bond is reasonable, $30,000 at 10%, with her being an out-of-state resident, and I think it's reasonable. So we're gonna leave the bond as is. The next date is March 1st at 9 a.m. All right?
Thank you, Your
Thank you
Honor.
very much.
I will just note for the record, Your Honor, when this got set for March 1st, I did indicate some objections on the entry. The reason I objected was at that point, I was told that this bond hearing wouldn't be till then. Given this hearing has been held, I'm withdrawing that objection.
Thank you very much, I appreciate that for the record. Anything else, State?
No, Your Honor.
All right, thank you very much. Give that just a minute. Wait time till the trial date. Is it time wait till trial date?
Yes, Your Honor.
All right, thank you.
Yes. Yes.
Yes.
All right, Mr. Ewing, you're gonna bring down your client, yes, okay? Counsel.
Wait, Your Honor.
Can you talk to the prosecutor?
We spoke, I've got paperwork, Your Honor, except for jury trial, I spoke to ask the court about transferring the veterans court. And I can explain the timing of the request.
Okay,
So we had this jury trial set for a long time. I needed some discovery to be able to review the arrest, and I got that. In the meantime, Mr. Ward lost his phone. It wasn't working, so was not able to communicate with him about making decisions about the trial. He is here today. In the meantime, he's also talking to Mr. Street regarding the Veterans Court. He is hoping to get transferred to Veterans Court, and Mr. Street and him were waiting for he and I to be able to resolve our issues with regard to the arrest, and we haven't. So we are hoping to maybe get another month, Your Honor. He's even signed the plea forms to resolve things, but he is wanting to go to Veterans Court if he could. So-
well, so, Mr. McKenna, how I do things is, we need to resolve this on the trial date. So, because I have a trial date,
Understood.
right, so all these issues, what you said is absolutely reasonable, but this is our trial date. So I don't move backwards off of that trial date, everything needs to work toward the trial date. I would have no objection to putting, transferring it to Veterans Court if he's eligible, but that needs to be done today.
Understood, Your Honor. And we're just not able to get to that point. So,
I'm not gonna continue 30 days.
do I have 5 minutes? Sure. All right, thank you.
Thank you.
That's right, that's one of those.
Yes, there's always one.
Mr. McKenna, do you need to come back or?
Before we actually do this, she might have another number than I do for Mr. Street. She's trying to reach and see if he can come by. Thank you.
Correct.
Ms. Howard?
Yes, no.
Okay, I cannot do anything more. There's a lot of extra circumstances.
Listen, yeah, that's fine.
What the
All right, these are the matters, we're back on the record on Mr. Fant and Mr. Jabari Walker.
Mr. Facts come into the room, Your Honor.
All right,
Carl Wilson has been. How much was he have Mr. Walker?
all right, so, Mr. Walker has jury trial on one of his cases, probation violation, and this new case. Yes, how do you want to proceed?
Your Honor, I can tell the court now that we are not prepared to go forward because we just received roughly 20 body worn cameras and 20 MVRs from the state last, we sent Tuesday, we downloaded Tuesday. started trying to watch it, I got through about a quarter of it. As a reporter to a third, as of Friday. So there's just a number on the fair reply that they just got to us. I did file a motion to compel, they've answered it, so there's nothing to argue about it, they have answered it, but. And I don't, and be fair to this Cody Act, and she came into this room, there's quite a bit, I understand, discovering a number of cases that have not been completed. So that was one of the answers. I spoke to Mr. Walker about that. He's aware of that, he was in agreement with that, he wants me to review this, discuss it with him.
All right. Let's pick trial date.
March 20th.
And that's, if I could just briefly tell him that.
What, March 20th?
No, March 20th, will be the next court date, we'll address the bond. So March 20th is the date that we discussed. That would also include the new case as well.
Mr. Lewis?
Your Honor, 1 second.
Yeah.
Your Honor, I'm sorry, somewhat, Judge, I apologize, Mr. Koriak. Mr. Ewan and I have been discussing this case, and as it relates to Mr. Fenton, we're waiting time. We're satisfied with the date, I believe, on March 20th, Judge. I was just talking to Mr. Ewing in the interest of fairness and justice regarding his client's position. And I'll speak at the appropriate time as far as dates, my client is fine.
What about the date?
Date is fine.
All right, March 20th will be the trial. Now, this is the thing. Mr. Walker has more than just the case with the co-defendant.
Yes.
And so, you want me to set them both on the same day? Because what I don't want to do is get to March 20th and then say, oh, we want to have two different trials for these matters because they're separate incidents.
I understand that.
Because I have a jury trial for this, for the old case today.
I understand.
So what is March 20th okay?
And Mr. Walker says that March 20th is okay for the work case as well.
All right, we need to find out pretrial conference, Ms. Howard.
February 11th. I mean, March 9th.
You use March 9th?
Yes.
Yes, Your Honor.
Great, March 9th, 9 a.m. Right now, it's in person, but if it's Zoom, we'll let you know. All right, and so, I have Mr. Fant, jury trial, March 20th, 10 a.m., final pretrial conference, March 9th, 9 a.m., and time is late. Was that accurate?
For Mr. Fenton, that is correct, Your
All
Honor.
right, anything, addition you want to discuss? On Mr. Fant?
Yes and no.
Okay,
He wants to wait for me to.
all right, well, Mr. Ewing, is there anything else you want to discuss on Mr. Walker?
Yes, Judge, actually, Mr. Walker, primarily on his older cases. Mr. Walker's out of bond, when he was doing everything he was supposed to do, and some charges got filed, he got revoked. That's part of the reason. He has a bond on the new charges, it's $9,000, 10% plus immunity. We were asking the court to consider reinstating the original bond, discussing with Mr. Lewis, and also confirming with the state. These allegations, the new allegations, involve one firearm, was in a book bag that is associated with Mr. Lewis's client, not my client. We understand, the state is not in a position today, really, further resolution as far as the new case in regards to Mr. Walker. We just asked the court to consider at least reinstating his original bond, given that he had been coming to court, and the new case appeared to be the reason for the resignation. And it sounds like it is not Mr. Walker's firearm.
State?
To further for Your Honor.
So in the case of the co-defendant case, we had one firearm, both charged?
Yes.
I see. Mr. Lewis, what do you want to say?
Your Honor, may it please the court, I find myself in a very awkward position, but the position is interest of justice at all times. I
told Mr. Corey after we're gonna work toward a resolution, why I'm not, I'm gonna make it very clear, making an addition of any kind. I did check with Mr. Corey and the officers to determine and do our discovery whether there was more than one firearm, and there was not. And in the interest of justice, I would join in my colleagues' request that my client receive an OR bond here. I'm not sure if there are other allegations regarding the probation violation, but the firearm at issue was found in my client's backpack with his ID. So while there might be other facts I'm not aware of, at this particular juncture, I believe it's pretty interesting that the one firearm is being used to hold this young man. Now we're joining in the interest of justice, the court consider reducing the bond. Co-defendant is not making a condition, but the weapon was found in his backpack, and the court seeks to do justice always. I believe that this young man should be released, Judge. With that, I'm going to shut up and leave. That's all I wanted to say. All right.
We appreciate it.
Your Honor, there was, and I didn't want to put this on the record until I received confirmation from the officer that it was permissible. Yes, there was one firearm that was found in the car. However, it is my understanding that there was a probation search conducted at Mr. Walker's residence, and officers recovered a drum and switches which fit the firearm that was found in Mr. Phan's vehicle. So there is a DNA analysis pending, I believe, closely done on the items that were recovered, which may straighten out some issues.
All right, excellent. So, Mr. Ewing, you're asking me to review the bond without a formal written motion, but
I
an
am.
oral motion.
I am.
Okay. All right.
Judge, I'm sorry. Mr. Phan, I excuse.
Yes. All right, oral motion to continue the trial on E-2203761 is granted and it's continued to March 20th.
Thank you.
With regard to the bond issue, the court has considered the factors in criminal rule 46 and the bond at this time is set at $9,000 at 10%.
And that's on the new bond, yes. Or, sorry, the new case, yes.
Yeah, new case plus E&D, and that's what you're asking.
Judge, I'm primarily answering the court's reinstatement. The original bond of the other cases, since they were revoked. I think Mr. Lewis asked the court to consider taking them in OR. I understand 9,000 at 10% is a relatively low bond.
That's on the new bond.
That's on the new case.
Okay, you're not talking about that case.
I'm talking about the other case.
Okay, thank you. This is why I asked for your writing, because you have to do a whole bunch of looking at stuff.
I believe the original bond was 10,000, 10% plus.
I'm just confirming. All right, the original bond on case ending in 3761 will be reinstated as 10,000 at 10%. No. That's not what it was. Looked like it was 10,000 for C and D.
Yeah, 10,000, 10% plus E&D.
Yes. Okay. All right, plus E and D, yes.
And probation violation, I think, may have been a war, I think he was cited in court on that.
And there'll be an OR bond on probation violation.
Thank
In
you
the
very much.
future, make sure you file a written motion, otherwise it will not be heard.
I appreciate it.
All right? Thank you.
Judge, you said, oh,
My client appreciation during the day.
Ms. Mallory, we've been waiting, I think your permission to do everything.
she's,
Oh, you're here,
oh,
yes, perfect, let's go ahead and do that. This is matter of City of Ohio versus Mary Ann Powers, case number B 210-2278. Ms. Powers is present in the courtroom with Ms. Ann Mallory, who is the appointed to represent her, and Ms. Jim is the prosecutor, and we wait for her. All right, Ms. Jackie Sekoyak is present in the courtroom. This matter is on for a probation violation. And counsel, have you received a copy of the community control sanction violation?
I have, Your Honor, and I reviewed it with Ms. Powers.
All right, thank you very much. Does she want probable cause hearing?
She does not, Your Honor.
All right, probable cause waived.
Yes, Your Honor.
What's the plea?
Your Honor, before we want to just report an issue, it appears that the recommendation for probation or the suggestion is that she enter into a civil agreement, which, a civil acknowledgement that she owes the money to the prosecuting witness. She doesn't oppose that, she is willing to do that. There are some issues, though, we're not exactly sure where the restitution goes. The indication on here, she doesn't believe that it's who is written on this entry here. So I don't know if the court is inclined to entertain that as an option, if the court wants to set this matter over so that I can look into that and have this information.
I have in the judgment entry, $2,171.18 to Walmart and $5,777.99 to Huntington Bank.
That is what is on here, but when I said that,
no, I thought the Kramer's was.
she believed it was to Kramer.
Yeah,
So there was some.
That's what it is, yeah, I thought there was like something.
Okay, so then we do have the correct information. Again, if the court is willing to entertain that as an option, then she is certainly willing to acknowledge that and sign the paperwork for that. Or wants to proceed in a different fashion, then
Well, I still need to know what her plea is.
She does admit the violation, she is alleged to have violated rules 4, 8, and 10, she does admit that.
All right, can I hear statement facts?
Yes, Your Honor. Ms. Powers was placed on probation following a conviction for theft, up to 2 counts of theft and forgery. Since being placed on community control, she has violated in the following ways. She tested positive for fentanyl on March 17, 2022. She failed to report for scheduled appointments on May 16th, June 20th, July 18th, October 17th, and November 21st of last year. And she's also failed to make consistent monthly payments to her court debt, which includes the amount of restitution which has previously been discussed.
All right, thank you. Ms. Powers, you heard the prosecutor said you did?
I'm sorry.
Did you hear what she said you did?
Yes.
Is it true?
Yes.
All right. Your plea is guilty?
Yes.
All right, it's a finding of guilt of probation violation. So, the restitution amount is just one part of the violation. So the violation is for testing positive and also for drugs and also for missing scheduled appointments. So a civil agreement is not going to resolve those issues, right? So, I think what you're asking me to do, Ms. Mallory, is terminate her unsuccessfully and let her return to us?
Well, that's what the recommendation from probation is, if the court is willing to entertain that, yes. I think there were some issues, she tested positive, that was approximately 10 months ago. Since then, she's been in treatment, she's at the methadone clinic. For 3 of those appointments she missed, she was in the mental health hospital.
And then I worked for, I think, 2 appointments.
I think the biggest issue is that she's not in a position to pay the money back, so that's her biggest concern.
Even though she works?
Well, and for the first year, I tried to get the money back, but my first probation officer didn't put the money into the system. So I paid the first probation fees, and I went a few times, and they told me, you don't owe me more money, and I told her. Every time I go to try to pay this, they said I don't owe any money.
Wait, Ms. Powers, are you telling me that you're saying probation accepted your money and it didn't get put in the system? Is that what you're saying?
Hey, so what I'm saying is, I don't think that they put all that I owed into the system. My probation fees was there, but not everything that I owed was there.
See, I had no probation fees.
I paid them.
And all the remaining is restitution.
Yes, there were times when I tried to pay restitution, but when I went to the probation office, they said that I didn't owe any more money.
Go to the clerk's office and pay restitution.
I'm not sure what happened.
Okay, all right, well, I've heard nothing to give me reason to terminate your community control.
I understand that.
All right. State.
Defer to the court, Your Honor.
All right. Anything you want to say else, ma'am?
I'm sorry, I could try to pay it if you'd like me to, it would take me a while.
So ma'am, this is the thing, it's not if I like you to. You took this money and you owe it. So it's not a matter of, do I like you to pay the restitution? Of course I would like you to pay the restitution. Why? Because you owe the restitution. Okay? All right. I'm going to restore your community control. I'm going to add a year. You are to report, not have any dirty drug screens, and make your payments. So I know that you had some confusion about where to pay it. You can pay the restitution at the clerk's office. They will accept the money and credit your account. She pays the probation?
There's a window here that can pay restitution at probation.
You'll help her get this squared away?
Yes,
Okay. Somewhere she pays probation, she pays her restitution. Somebody's gonna accept her restitution.
It sounds like they initially took her payments for the probation fees and not toward restitution, and somehow
That shouldn't happen.
it sounds like it's in the system now.
Yeah, all right, so I'm gonna remit any future court costs, probation fees, or fines, okay? Because I want all money to go to the restitution amount. So I'm gonna put that probation fees remit. Every dime you pay now is gonna go to credit toward the restitution that you owe. And if you violate again in the next year, you open yourself up to, potential prison sentence. Do you understand? Ma'am?
Yes.
All right. And that would be up to 12 months because these felonies in the fourth, fifth degree. All right, anything else, counsel?
No, you're right. Thank you.
State, all right, you have the right to appeal your conviction and sentence. If you choose to do so, you must do so within 30 days. If you cannot afford the process of the appeal, the attorney will be appointed to help you at no cost to you. Ms. Powers, do you understand? Ms. Powers, do you have any questions for me? All right, thank you. Mr. McKenna, you have any word? Mr. Bennett, come on up. Mr. McKenna, you have any word on your?
I'm the Mr. Street has been treated by Your Honor, and I mean, the only reason we would ask the court to consider the transfer is he has a prior felony. He's engaged, he has a prescription for Suboxone, he's got a follow-up visit with treatment at Joe Dale.
I have no doubt that he may be eligible, and if he is eligible, I have no problem. My issue is, what has to be done for him to be eligible?
We have to get all of Mr. Street, who just asked for more time to do that, Your Honor. It's.
And Your Honor, I asked him to give him what I believe is Mr. Street's number. I sent him a text message at 10:54.
Yeah.
And he has not responded.
Okay. Let's put this, when we'll take some March first. Would you say there's any more March first dates?
March first, it's on March first?
Yes.
Yes.
All right, March 1st, 9 o'clock. Now, I don't want this to get transferred on March 1st. I want it to be transferred before March 1st.
Understood, Your Honor.
So that's what I'm hoping this will happen.
I'll get all of Mr. Street and get him in touch with Mr. Rowe.
Let's continue for status. March 1st, 9 a.m. And I'm fully expecting this case to be transferred to Veterans Court. Right? Oh, you have it.
I just got a response.
You got a response to that. Let's see what she says.
Okay, so he said that yes, he was/is on his radar to be considered. He initially looked at him around Thanksgiving. His notes indicated that they were exploring a defense at the time, so that court option was put on hold. He certainly can be looked at closer if that is what he and the attorney would like. He's off today, otherwise he would come over and talk to everyone today. If a short continuance could be granted, he would reach out to the defendant and his attorney to see if he's a good fit to be transferred.
Thank you.
March 1st.
Thank you.
But now, handle business so that if it can be happening, we can get the transfer done before.
Yes.
Okay, thank you. Have a good day. Time away.
Yes, Your Honor.
All right, Mr. Bennett.
So he wants to talk to you.
Mr. Ask.
Oh. When he's here, set a trial, I'm sorry.
And then he was just stop it back for Mr. Ask.
He is stepping more than.
You can talk about it, ask him.
Are you Mr. Ask? Wait on your attorney. maybe 2 minutes or so. Is that what you think is, so I would do it in 10 minutes or so?
Last time I texted him, he said he got stuck in the room, and then he said, it was at 10:45.
Judge, can I call the video case?
Yes.
He's in the hallway, I recommend his appearance for the purposes of this conversation.
Okay, is, Mr. Bennett, are you guys work yours out there?
But I think, you're not accepting the cost if they don't go with it.
Or you want your trial to go?
We have another trial set and another one that's a lot older than this case. And so if their case is going to go, we have to reset this one, all right?
Yeah, that is accurate.
Yeah, that's not the question.
We have not reached a resolution.
Okay.
The options are either an agreed plea, Mr. Bennett inclined that he is not interested in, or just pleading both to everything and getting a pre-sentence investigation and letting your honor.
This has been a while, I'm ready to resolve it. So, all right, stay tuned. Zatato,
Yes.
what's happening?
Judge, the state is ready to go.
Defense is ready to go.
Oh, okay. And so we had some conversation, last week.
The victim is here.
Was it you?
Yes.
Let's see, I think that Mr. Bennett, you are in trouble.
Mr. Bennett wants to, be happy.
I was trying all that, I was no trouble, so.
Mr. Picado is much older, obviously.
Then Mr. Bennett.
Mm-hmm. Than Mr. Bennett's case. Yeah. So, All right, let's, give just a minute, a new date. Is your client here?
Yes, he's in the hall, we won't bring him in.
No, as long as you.
He's sitting in the hall.
So what we can do is, if you get a trial date on Robinson, great, if not, you can put it on my backlog, document. All right, Tasha is ready to go. And, and then is Mr. Cluskey. Where's Mr. Cluskey?
Last I heard, he was upstairs talking to Mr. Jones. A plea offer has been made. I think they're close, but I think if you have some time to think about it, that's what I asked her to discuss.
Tata is older, but he's out. This guy is in, and I need to know what they're gonna do. And I'm ready for Tata, so.
And again, if they want to go forward, that's fine. We're here for them.
Judge, I'll try to,
That's fine. This is, you know. Can you send this to Cluskey a text real quick? Mr. Bennett, what time is he? Send Cluskey a text real quick and tell him when he's down here ASAP.
yes.
Judge, if McCluskey's case doesn't go and Mr. Fox might go, were you thinking maybe like a certain time to have the jury brought in? I'm not sure if there's a deal up there or whether they were planning to go to lunch before we start.
We probably need to let everybody go to lunch and start fresh after lunch at 4 o'clock.
That sounds great,
But
Judge.
let me just do some triage real quick, okay?
No.
Miss, thank you. Can you call it to, where is it?
We're not waiting for trials.
What?
We're not waiting for trials. We're not waiting for trials.
I'm trying to figure it out.
Okay. Okay.
Mr. McCluskey said they are reviewing the plea forms right now.
Okay. That doesn't tell me anything. Reviewing.
This is like purposely vague.
Yeah.
Judge, there's one other thing that I wanted to ask the court's permission. Josh Evans has, he's looking to get initial trial experience. He asked if he could sit second chair with me. My client's okay, I'm okay. We have to have Mr. Teeter is fine with that. I just asked the court, because he has not previously been in the case, if the court would be okay with that. He's not gonna question any witnesses or.
Well, this is not everybody's agreement, that's it. But my issue would be, distracted. I don't want to go to his phone, I don't want to crush ice, and I want him to sit still.
That would be my
Now, if he can do any of that, all of that, I'm good with that. If not, to do it, I'm saying.
Pick March 20th.
All right, March 20th, wait time, Mr. Bennett? Mr. Kodiak, that good?
Yes, I checked with the officer, Your Honor.
All right.
Yes.
We don't need another final quick trial.
No, you don't need one final pre-trial. So, I'm ready on the 20th of March, Mr. Bennett.
Mr. Bennett, you ready, Tom?
No way, God.
Congratulations, I heard you, did well last week.
Yeah, that's that's.
Today's a new day. Oh, yes, so it's funny.
Yeah, let's see what.
Okay.
So, Mr. Kodiak, you gonna try to.
Yes.
Mr. You're gonna try to.
With Mr. Bennett and Dr. Fox, yes.
Okay, and, the only thing I want to know is,
Yes, I believe Mr. Teeter is going to stay, and Mr. McCluskey, as I said, he said they were reviewing the big forms. I asked to sign them, and he said yes.
Okay,
So that should take care of everything.
so Mr. Teeter's gonna help out the rest of the.
Yes.
Thank you, all right.
Judge Triggs.
Mr. Southard should be on his way back because Mr. Askins is separate plea.
Yes, sir.
And, Mr. Jones should be down for the plea and we'll have to talk to him.
Are we free to come back?
Not yet, so the jury commissioner is getting ready to let us know when we can get the, questionnaire. So if we're gonna come back at 1, I want to be able to give you questions beforehand.
I'll wait.
Are you glad you didn't go to the game?
No,
Well,
I'm still unhappy. I will never forgive Mr. Tinker for this. But you know what's funny? I finally started to get my voice back this morning
from,
streaming at the television.
yeah,
This morning,
yeah, it's very exhausting.
really did not. It was bad. So,
It was a bad call. That led to the penalty that gave him 15 yards to get closer. That was
Have you ever seen a 3rd and nothing, a team doesn't get it, and it's like,
yeah,
let's do that one more
just
time.
did that over again. Yeah, it was,
I've never felt that in my life.
it was unbelievable. It's like that
My whole
was.
life, it's like, that something's going on with stuff.
It was unbelievable. And you know, that Taylor, he's still, you feel some way about that. But, the coach he was like, about to jump out of his skin. It was just so unbelievable.
I thought he was gonna get this all. You know, he's running down the field. What I feel, you know what I mean? Like,
We're all good.
imagine doing that all season. Like, what was it, 12-game, something 12-game crazy, good streak. And
Watch Bill win the 49,
I
It was the same thing.
Yeah.
I'm not a football person, but they did that the whole way. I think it was just, and then the last call was that.
that was
It was very call.
he was fun.
They were on their way out of bounds.
Yes. And he's running full
It's
speed.
full speed, you can't stop yourself because the line is.
You would think they would have.
Yeah, and it was so clear. It was so clear that, because we were getting ready to do what they did. And this guy went to the game. I was like, we're going to win that, we're going to win that. Yeah, it was bad.
Hey, Mr. Fox,
Our guys are so.
did you, I
They're so good. My husband's great with the people.
was gonna maybe,
We had some, we had some.
Because he's never this last week, so like,
So the girls that. He was screaming at the TV. Yeah. All right, so we are waiting on a few lawyers, and, Mr. Askins, I apologize for the delay. I know you've been sitting here a long time today, and I know your attorney has been here a couple of times. And he would come when I was in the middle of something, and when I would try to get to your case next, he would be here. So I apologize for your delay, we're gonna get to your case as soon as he gets back.
Hey, Judge, I've got, I know you mentioned before there was that affidavit by the victim and the mother about not wanting to show up and all that. Let me go real quick here. They're on the fourth floor, and we are definitely not gonna get to them today because of jury selection. We'll probably will get to them tomorrow sometime, maybe after lunch. Would it be okay if I brought them in the room and then have you tell them that they're continuing duty to appear, and maybe give them the time tomorrow that they would need to be here?
That'll be fine.
All right, go ahead.
I think, is it fine if I leave him in the hallway, or do you want to for this, or? I'm fine. It's entirely, you know what I'm saying, I don't wanna,
Yes,
I don't wanna be involved in that decision making.
yes, okay. I think he has a right to be here at every important stage, so I'm going to have him in.
Great, you want me to get him?
That would be great. Have him sit over here.
They're gonna be fun. Judge, I thought it was interesting when we had Erica on the phone last week, and you had asked her about, she said she's still contagious. And you probably remember, we said, well, you're not coming to my room. You said, well, then not your room, but I am coming to your room. And Terry and I were just like, wow.
I know,
Yeah,
but you know what? I'm so over it.
yeah, I'm very
And
okay.
I'm like, I have to monitor what I say
Yeah,
because I feel some kind of way about it.
yeah.
And I'm just like,
I mean, we had gone, I feel
zip
bad.
it, just zip it.
I feel bad for you and Mark and her because if I do Valdir again, you will have already heard all these questions before, so we will see how that goes next time.
Yeah, I did notice that same
Yeah.
spot in your room.
Oh, yeah,
I
yeah.
did, I noticed it.
It's optional, but yeah.
And that's why I said, note to self.
Yeah, you were right, okay.
Just, okay.
Yeah.
Ms. Stacy, did you say you called us? Did Mr. Side say you called us?
I'm good.
Yeah.
Thanks, Patty, I appreciate it.
Excuse me, officer, what case are you here on?
Shopper Jones.
Okay, thank you very much. His lawyer is upstairs with him right now, so they should be down any minute momentarily.
Thank you.
You the one that's hanging around? I'll cover the jacket.
Oh, I didn't know what this was saying.
Just do. Okay, there's sugar over the law offices here.
There was a lot of, I know a lot of them were on.
Do you believe?
I mean,
I mean, are you the main case officer?
No, it's a-
Okay, you're good. All right, thanks a lot.
Mr. Fox, how do I pronounce, is it Vitato or Vitato?
Taco. I always say, is it a taco? I change it up each time to keep it interesting.
All right, you can just stay right there. This is the matter of State of Ohio versus Charles Vitato, case number B 2105562. Mr. Vitato is in the courtroom, present with his lawyer, Mr. Brandon Fox, Mr. Septima from the state of Ohio. This matter is on the jury trial today. We are in a holding pattern right now, just waiting on the jury commissioner to organize the jury questionnaires and so they can be released to the council. But it appears to me, given the lateness of the morning, that even starting today, we will probably and likely only get to one year, maybe opening statements, not sure. But in any event, probably not any of the evidence will be presented today. Given that status, Mr. Teeter, what are you asking?
Judge Shayla Woodley, that's not right, is in the courtroom. She and her mom, who's the defendant's wife, have been personally served for today at, I believe, 9.
Okay.
Recognizing what the court just said, that we are not going to call in as witnesses today, I would feel bad if I made them sit around today all day till 4 o'clock, only to tell them that they need to come back tomorrow. So I would ask the court to direct them. I'm thinking maybe noon, because I think we're gonna have a problem getting a jury today, even if we do openings tomorrow morning. I have at least 1 to 2 witnesses before I would call her anyway, so I'm thinking tomorrow around 12.
All right, thank you very much. So, is both witnesses? Both?
She's a victim advocate for CPD judge, so
Okay.
her mom is not in the court, but we can let her know tomorrow at noon as well.
All right, and so, ma'am, I just want to let you know that you are under continuing obligation pursuant to the subpoena to come back tomorrow, all right? And so, yes, you are right, and I think probably you'd be likely to take a lunch break at noon. But if you want to talk to your witness before that, I can
That's
have.
quite the way we do it.
All right, and so I'm gonna order that you return, or request that you return pursuant to the subpoena at noon tomorrow, okay? All right, and then you may leave for today, but just understand that there's a continuing obligation of the subpoena, okay? Thank you very much.
And then it would probably be a good idea if you would just wait outside, because there'll probably be a separation, and that way you could meet her outside around the.
Yes, you have time to talk to her.
Yes, Judge.
Okay.
Just for scheduling purposes, I've never had the opportunity to do a jury trial in this room. Do you go 10 to 4, or do you stay later or come earlier?
We will go to 4, but if we're very close to concluding a matter and it's 4 o'clock, we will stay until we conclude.
Okay, great.
All right,
So
so
what do we think tomorrow at about 10 is
No. We're still waiting for the jury commissioner. I'm starting this today.
No, I'm sorry, Mayor. For beginning tomorrow, assuming we.
Oh, to start tomorrow? Yes, 10 o'clock.
Just so they can let the court.
Oh, yes, that's right, 10 o'clock.
Thank you.
All right, so we'll be in recess until the jury commissioner gives us our jury, Ms. McCluskey, you ready for Mr. Jones to come down?
Yes, please. Sure, good.
Do we have it worked out, Mr. McCluskey?
Thank you, Judge.
Oh, thank you. Are you drawing a motion to suppress?
Yeah, I think, I assume she could go the other.
No, Mr. Tinker is going to talk. Well, why don't you then talk to Mr. Tinker real quick, and then all the documents to sign?
Yes.
Okay.
Yeah.
Okay, yeah. Okay. This is you. We did.
Yeah, it's coming back.
Make sure you, put it on. No, like this. Oh.
What's your state name?
I'm sorry.
What's your
Police officer Tiffany Green.
Green,
Yeah.
and with the E or?
I don't think it does. I think it's a problem.
Going to a plea, and then I think 2 pleas and then a trial. Askins, yes.
So you have an idea of who you're gonna call?
Yeah.